Hello, everybody. This is Bruce from Oregon with the Bruce from Oregon Show. This is episode 0. It might be the first, it might be the last. We will find out. Now, today, I wanted to do another Court of X video, but we're really not on Twitter. We're going to go to medium.com and look at a blog post. So it's sort of the Court of Medium, if you will. We'll get to that in a minute. Today's guest cat for the video here in the browser is Unruly Bonker. Unruly Bonker is hanging out, looking good, with a slice of pizza. Pizza sounds good. Oh. But we don't have time for pizza right now because we're going to get into this blog. We're going to take a look at it. This blog, let's get into it here, on medium.com. It's written by Laura Owens. Laura Owens is the petitioner in the Owens v. Echard paternity court case that Dave Neal and others have been covering over the last year or so. If you're not familiar with that, there are various places online you can read up and listen to videos going over the court case, which I won't do here. We're in the post-appeal phase of the case, and this is, I guess, Laura's response to the post-appeal ruling that ruled against her in her appeal and upheld the original ruling, which was a victory for Clayton Echard, the respondent in the case. So what we're going to do is go through here with my personal commentary, talk about what I think about all this, and sort of analyze the text a little bit and see if that's interesting. If you want to hear this blog post without any commentary, you can go check out Schnitzel Ninja on YouTube, who reads through the court documents and other blog posts without commentary. And then typically we go do commentary on Lauren Neidigh's channel. I didn't get to do that for this blog entry in this case. I was on a secret mission. My mission went sideways. I got sick, and I've been out of commission for a while. But we're back here today. It's March 31st, 2025. This thing says it was posted 16 hours ago, so it's hot off the press. And we're going to take a look at it and get into it and see what we can learn, okay? And I'll try to go quickly, but I think it's going to take a while. So this could end up being a long video, but that's what we've got. All right. Now what I'm going to do is I'm going to highlight the text as I read the blog, so you know I'm reading the text. And when I inject my own commentary, I will stop highlighting. So that's how you'll be able to tell whether I'm reading or doing commentary here. This thing is called One Paternity Petition, 6-Figure Sanctions, and a fight that could go all the way to the U.S. Supreme Court. Well, this sounds very dramatic. Okay. Now, here's the problem. It says 6-figure sanctions. Yeah. If you go to court and you start having a long embroiled battle with someone that includes lots of motions and an appeal and in-person hearings, you will rack up a huge legal bill. I mean, this is very straightforward. It's not unreasonable that you could rack up a very large legal bill by engaging in legal action. So I think she's starting off sort of complaining about that, but I think that's a little unreasonable. And then she says, in a fight that could go all the way to the U.S. Supreme Court, which is, you know, that's a lot of sort of rhetoric. I mean, there are a lot of things in life that could happen. There's a lot of things on the planet that might happen. It doesn't mean they're likely to happen. It doesn't mean they will happen. So this is sort of a speculative statement to, I don't know, make this whole thing sound a little bit grander than it is. I mean, I don't know. Good luck going all the way to the U.S. Supreme Court. We'll see how that goes. Oh my gosh. Let's get into this blog, shall we? When I filed a paternity petition against Clayton Echard, a former star of The Bachelor. Okay. And I don't know why she's doing this thing with these EM dashes to sort of break her sentences apart. There's no need for this. Just write short, concise sentences that take advantage of economy of words. I have a whole video on my channel in the management section about economy of words. You can check it out. I don't like this style. I think it makes it hard to read and understand, but that's where we are. I trusted the court system would do what it was built to do: evaluate facts, apply the law, and deliver fairness. Now, this is interesting because we're still in the first sentence, and she's making a very serious claim here. She's claiming that the court system in Arizona, in the jurisdiction of Maricopa, the jurisdiction of Tucson, failed to evaluate facts, failed to apply the law, failed to deliver fairness. Now, evaluating facts and applying the law, I think the court system did do those things. I've read through the original ruling by the judge. The judge's superior or supervisor ruled on some post-hearing motions, and then there was an appeal that went through a 3-judge panel in Tucson. And all of it seemed very straightforward to me. So if you're going to claim that 5 different judges somehow have this vast conspiracy to fail to evaluate facts, to fail to apply the law, and fail to deliver fairness, that is a very serious claim. And, that requires a lot of good evidence. And I don't think we've seen any evidence of that yet. We'll keep reading and see where we go from here. Okay. And then finally, delivering fairness. Whether or not a ruling is fair or not, this seems very subjective. Like, who's to say what's fair or not? There's no scientific test. There's only human, judgment in terms of the reasonableness of something. Given that Miss Owens has lost her case, lost many motions, lost an appeal, I'm sure she feels like it's unfair. I keep losing. How can that be fair? But that's a feeling. And we don't have a valid pathway to truth through feelings. We have a valid pathway to truth through evidence, through logic, through reason, and through the scientific method. So Miss Owens needs to stop relying on her feelings and start developing a more scientific mindset. Okay, that's my take here. Let's keep going. I had medical documentation of my pregnancy. I disagree with this claim as well. During this case, Miss Owens had positive HCG tests and nothing else. Positive HCG tests are merely indicators of pregnancy. They are not proof of pregnancy. Human beings can have HCG in their system, chemically, biologically, for a variety of reasons, only one of which is pregnancy. So if you want to claim you are pregnant, you actually have to prove it with good evidence, clinical evidence. You can't just say, I had HCG in my system, therefore I must have been pregnant. That's a logical fallacy. I will get into the form of that logical fallacy and other examples of that to illustrate why it's a logical fallacy in a subsequent section, because she repeats this claim even more boldly later on. I just wanted to point out here, I can't believe this claim. She keeps conflating an indicator with proof. If I have a headache, it might be an indicator of a brain tumor, but it is not proof I have a brain tumor, because human beings can have headaches for a variety of reasons, a brain tumor only being one of them. And so she's making that same logical error here. Okay. Then she says, more than Arizona law even requires, and every legal right to file. Okay, so she seems to think people don't think she had a legal right to file her paternity petition, but nobody's made that claim. She does have every legal right to go to court and file whatever she wants in court. Nobody's disputing that. The problem is, once the respondent of your court action files a response, then, there's this process that starts where the court action has to complete. And what happens during the completion of that court process is going to depend on the quality of the evidence you bring as the petitioner to make your case. And in this case, we saw the petitioner failed to bring a lot of good, compelling evidence to prove their case. So, really, what this is about is not that she filed a paternity case, it's about what happened during the paternity case. So, this is sort of a red herring. It's what I would call a straw man logical fallacy. She's saying, hey, I had the right to file this case. Well, of course you did. Nobody's saying you didn't. So she's arguing against an opponent that hasn't even made the claim she's arguing against. There's no utility in that. It's really sort of a worthless sentence. Okay, let's keep going. What followed was not only a pregnancy miscarriage, and again, we have to stop here because during this case, Miss Owens never provided clinical proof of miscarriage. She never provided clinical proof of pregnancy, and she never provided clinical proof of miscarriage. She merely said, I'm no longer pregnant. Well, the default state of all human beings, after they're born, they grow up, they become adults, is to not be pregnant. Like, you have to become pregnant, and then you have to be in the pregnant state in order to have a miscarriage. And she failed to provide clinical evidence of either of those claims. So, this is just another one. It's a claim with no evidence. What can I do with that? I can't do anything with it. If she wants me to believe her, she has to provide high quality evidence. Okay. What followed was not only a pregnancy miscarriage, but also a miscarriage of justice. I'll give her points for, using a verb twice for two different things. It's kind of a cool linguistic trick. It's very literary. I don't know. But anyway, a miscarriage of justice so severe it demands public scrutiny and judicial correction. Oh my gosh, guys, this is a very, very serious claim again. It goes back to the thing about evaluating facts, applying the law. She's saying a miscarriage of justice occurred that demands judicial correction. I mean, I don't think any of the 5 judges that worked on this case agree with this position. I don't think the majority of the general public agrees with this position. I think this is just her opinion. And if you want me to be on your side and agree with this opinion, you have to provide a lot of compelling evidence. And so far in this case, I have not seen that evidence. So again, this just seems like some inflammatory rhetoric, which is opinion-based, not fact-based. Let's keep going. She says, if you're interested in the background, what led up to this petition, the harassment and the personal toll. I mean, what about the personal toll? Is there a verb in there somewhere? I mean, again, and this is the problem because she's using these EM dashes and breaking this into a big, long run-on sentence. It's hard to read. It becomes difficult to parse. So from an editorial perspective, guys, again, whether it's semicolons or EM dashes, just avoid those. Just write crisp, clear, concise sentences to get your point across and to provide an explanation of what you want to convey to your reader. Okay. You can find my full story here. Okay, that's fine. I guess my problem here is really like, if you filed a paternity petition against a public figure, former star of The Bachelor, and it took a personal toll on you, like, what did you expect? Did you expect filing a petition against someone in court to not take a personal toll on you? I mean, even if someone knows they are 100% in the right and they need to go to court to prove it, that is going to be an arduous process, even if you're in the right. Even if you are seeking justice, it will take a personal toll. So complaining about it after the fact, I think, is a little disingenuous. Also, here she mentions the harassment. If you're going to claim that people have harassed you, you need to, again, provide evidence so that we can believe that people harassed you. Especially, if you are going to claim specific people harassed you. If you say, look, I've been the victim of harassment online from random trolls, I'll probably believe that claim because online, random trolls will go write terrible things or send people DMs and say and do awful things. Okay. But if you're targeting a specific person, like one of the respondents in the case, or a witness, or a podcaster or a blogger or something like that, and you say, "Oh, they're harassing me by covering this story." I need to see some evidence. Covering a court case, covering a public court case on YouTube is not harassment. It's fair use, it's journalism, it's commentary, it's entertainment. I mean, it's all of these things, but it is not harassment. Okay, let's keep going. But this essay isn't about background. Okay. And then there's a semicolon. Don't do semicolons, just write short sentences. It's about what happened next. It's about what happened next. I mean, we're in the post-appeal stage. Okay, it's very dramatic. I believed the Arizona Court of Appeals would correct the clear and devastating errors made by the Maricopa County Superior Court in June 2024. Okay, this is interesting. She believed the Court of Appeals would correct the errors. My understanding is that appeals statistically have a very low chance of succeeding in court, like maybe 20% or less. I think I even heard someone say something like 10% for family court or this domain in Arizona. 10, 20, 30% success rate for appeals, those are not good odds. So mathematically, I don't know why you would believe that the Court of Appeals would correct these clear and devastating errors that you claim exist. It's irrational. Again, I think we're going back to, and again, we're using the word belief. You can't get to truth by just believing something. Okay, I believe I'll get $1 million tomorrow. Like, no, you have to have confidence based on evidence and science. Okay, that's how you get somewhere in terms of making good predictions about how the universe and the world operates. Okay. I don't know what the basis for your belief is here, and you haven't explained it. At least not yet. So let's keep reading. The other problem here is that, again, she makes the claim that there were clear and devastating errors made by the court. I don't think that's an opinion shared by the 5 judges in this case, the general public, the respondent's counsel. It's only a claim made by you. You have to convince us if there were clear and devastating errors, and I'm not convinced. And the way to convince people is to have a conversation and figure out what evidence you do need that will convince them. And there's really no conversation here. This is just a one-way blog post that's trying to, tell us something instead of interactively showing us why they think they're right. Okay, I'm not going to believe someone just because they tell me they're right. You have to show me why you're right. Let's keep going. Instead, they reinforce them. Yeah, I mean, the appeal ruling upheld the original ruling, as well as granting attorney's fees, to the respondent. Okay, let me explain exactly how, and another dash, and why this case matters to everyone, not just me. Okay, you can try. Let's see. Number 1. Okay, we're finally past the preamble, guys. We're 20 minutes in. This is going to be a long video, but, we're having fun. I'm feeling better. It's raining outside. I'm not going to get any yard work done. This is what we're doing. Number 1, they upheld a ruling built on evidence that never existed. What? Okay. Oh boy. The one of the problems here, of course, is that Miss Owens is the petitioner. She filed the paternity case. She said, "I am pregnant with the respondent's twins, boy-girl twins." She made the original claim, and of course, the burden of proof when it comes to debate, when it comes to reasoning, when it comes to logic, the burden of proof is on the people that make the claims. It's not my job to prove that she was never pregnant. If she makes the claim she was pregnant, she has to prove it. I have no burden. The respondent had no burden. Okay? Again, the default state of human beings is not pregnancy, not being pregnant. If she's going to claim she's pregnant with twins, she has to prove it. So let's see what she says here. In her June 18th, 2024 ruling, Maricopa County Superior Court Judge Julianne Mata included a critical error in her findings of fact. She claimed that Echard's expert testified the Planned Parenthood clinic I referenced was closed on the day I visited. Okay. Now, the ruling does claim that Echard's expert testified the Planned Parenthood clinic I referenced was closed on the day I said I visited. That's true. The problem here is that Ms. Owens says this is a critical error. And the problem is that Judge Mata's superior, Judge Fisk, and the appeals court, 4 other judges, all affirmed that this was not a critical error. It was a trivial error or a harmless error. Okay, a harmless error, like a typo, like if they said, Miss Bruce the Moose instead of Mr. Bruce the Moose. Like it's just kind of a harmless error, okay? The reason it's a harmless error in this case is because the detail about whether or not this Planned Parenthood clinic in LA County was open or closed on a Sunday is irrelevant. Whether the, claim that the expert testified about it or not, whether that information is true or not, everything about that information is completely irrelevant because no Planned Parenthood anywhere ever sent a legitimate, valid, confirmed ultrasound directly from the provider, the Planned Parenthood clinic, to the respondent's attorney, Greg Woodnick. Okay? So Greg Woodnick never received any legitimate ultrasounds from a provider. So the details about whether a Planned Parenthood was in LA County or some other county, whether it was open on a particular day or not, it's all irrelevant because there's no foundation for that detail being important. There's no ultrasound that was sent from a provider to the respondent's attorney. And because of that lack of foundation, any discussion about an arbitrary Planned Parenthood in LA or, somebody's testimonial claim that they went somewhere or did something, it's all irrelevant. It's harmless error. It doesn't matter. The ruling would be the same regardless of whether or not this information was correct or incorrect in this ruling, because this information just doesn't matter. So there's a fundamental problem here with her assessment of the original ruling. She's just got it wrong. She hasn't demonstrated why it's important. That's where we are. Okay, that testimony does not exist. Correct. It was never offered, never entered into evidence, and appears nowhere in the transcript from June 10th hearing. Correct. The expert never said it, and neither did anyone else. Correct. But the point is not whether or not it was correct. The point is that it is irrelevant. Then she goes on to say, this was not a clerical mistake. Well, we don't know why this error happened because the judge did not explain how this error happened. If we have no explanation, trying to root cause an explanation for something that you don't know about is conjecture. It's subjective. It's speculation. It was extrajudicial. This is speculation. We don't know anything about why this error is there or how it got there or what happened. So to claim it's extrajudicial, I don't know, it's just speculation. The alleged product of Judge Mata's own independent research, alleged. You can allege that she was abducted by aliens. It doesn't make it true. You have to prove your claims with good evidence that can convince reasonable people that your claims are true, which is not a legally permissible source of evidence. Right. But again, let's say you took the original ruling and just went back and took out that whole part about Planned Parenthood being closed on that particular Sunday. Nothing in the ruling would really change. It was irrelevant. There was no ultrasound from that LA Planned Parenthood sent from the provider to Greg Woodnick that could be confirmed as legitimate. So it's all irrelevant. I don't know why she's spending so much time here. It's like she's just grasping at straws for anything she can cling to hold on to her feelings about this case, to hold on to anything that can give her an internal feeling of validation of being right. And that is not how science works. That's not how logic works. That's not how the law works. I'm just sorry. Your feelings about this are irrelevant. Your speculation about this is irrelevant. Okay. She goes on to say, Arizona law is clear. Judges must base their rulings exclusively on evidence presented and admitted at trial. According to ARS 12-2103, appellate courts may only affirm rulings that are supported by the trial record, meaning evidence formally admitted during the proceedings. Okay. When judges introduce outside information, the fairness of the process is compromised. That's not a technicality. That's a due process violation. And this is true if the basis of the ruling, the foundation of the ruling, is based on a whole bunch of extrajudicial information. Okay, so if a bunch of people testify and the judge says, you know, I went out and did my own interviews, I went out and did a bunch of weird things, and because of the things I did, I'm making a particular ruling. Yes, that would be a due process violation, but that is not what happened here. There was an error in the ruling, which is effectively harmless. It is not the basis of the ruling. It's not the foundation of the ruling. You've done nothing here to demonstrate that that error, that harmless error, is the foundation of the ruling. And that is why your argument is failing, in my opinion. Okay. The appellate court acknowledged the mistake in their March 28, 2025 ruling, but dismissed its importance. Of course, I mean, they dismissed its importance. I just dismissed its importance. It's good to know the appellate court and I are on the same page. Quote, even assuming the court erroneously relied on information not in evidence, Owens fails to explain how that reliance prejudiced the outcome of the proceeding. The court didn't even rely on the information not in evidence. They simply mentioned erroneously information not in evidence. They never relied on it, number one. And number two, that reliance, if it existed, didn't prejudice the outcome of the proceeding. So if you want to make this argument and make it work, you have to do those two things. You have to explain how the court relied on the information to make its ruling as step one. And then if you do that, you can proceed on to step two, which is showing that that foundational reliance altered the outcome of the proceeding. None of which was done in this appeal. That's why you failed your appeal. I mean, there may be other reasons why the appeal failed, but You're not getting anywhere because you failed to do those foundational two things. Sorry. Let's keep going. The law doesn't require a showing of exact harm. Courts have long recognized that when credibility is assessed using material outside the record, the error is structural. It's not structural in this case. It's harmless. Again, you haven't demonstrated that the error is structural. It undermines the integrity of the proceeding itself. The appeals court disagrees with you. Do you think you just, the appeals court's just wrong? Like, what kind of hubris is this? I don't know. The appellate court had a responsibility to step in. No, you filed an appeal. They looked at it and they made a ruling. That was their responsibility. They didn't have a responsibility to side with you. You argued, the other side argued, and the judges made a judgment. That's their responsibility. They don't have a responsibility to side with you. You can't make the argument, if I lose, something unfair happened. That's not how it works. Instead, they shrugged, and in doing so, set a dangerous precedent. Oh my gosh. And guys, the dash, the colons, I mean, this is not a place for a colon in this sentence. This doesn't make any sense. The grammar here is just not, it's not doing anything for me. A dangerous precedent. Let's talk about that dangerous precedent. Here's the problem. This was a family court paternity case. The judge made a ruling based on law. The appeals court upheld that ruling. There's no new precedent here. We are not creating new precedents. We are not creating new law. Let me say that again. There are no new precedents here. The judges looked at the existing law that is in use in Arizona 24/7 for as long as these laws have been codified in the state and utilized those laws to make a judgment. That's how court cases go. There's no new precedent here. There's no new law. This is just wrong. There's no precedent, let alone a dangerous precedent. Claiming it's a dangerous precedent is just adding inflammatory adjectives to your sentence anyway. It's not convincing. Again, show, don't tell. Okay, one where judges can import unsupported claims into their rulings. No, they can't, because the unsupported claim was harmless error. Harmless error is irrelevant. Okay? If you're saying like, oh, you can't have a ruling from a court judge unless it's devoid of harmless error, I mean, I'm a fan of perfection and discipline, but it's unreasonable. Okay? If they say, Bruce the goose instead of Bruce the moose, it's harmless error. Okay? If they get my name wrong in a court document or something. Anyway, let's keep going. This is a permission slip for judicial overreach. No, it's not, because the laws are exactly what they were before this case. There's nothing new here. Nothing new has happened. There was a harmless error in your final ruling. There have been harmless errors in lots of rulings, I am sure. There will be harmless errors in lots of future rulings. It's irrelevant. It's nothing special about this case. Oh my gosh, guys. We're on to section 2. We're an hour in. Let's get into section 2. Section 2. They ignored Arizona law and my medical evidence. Wow, these are strong statements. Stronger than my coffee. Oh my gosh, guys. Arizona law does not require proof of pregnancy to file a paternity petition before a woman gives birth. Okay. So what? Under ARS 25804A, all that's required is a good faith allegation. Fair. I went far beyond that. I would say you did not go very far beyond that, actually. That's a subjective assessment, and I disagree with it. I submitted lab-confirmed blood and urine HCG tests from 2 separate medical providers. Proof of pregnancy backed by science, not speculation. Now, here's where I get upset. She brings in science. Okay. And again, she's very clear. HCG tests. Let's go through why this is a logical fallacy, shall we? And her claim is just wrong. Okay. If a person is pregnant, then they will have HCG in their system. Okay. This statement, which I think we can all agree is generally true. I mean, maybe there's a pregnant person without HCG in their system or measurable HCG in their system. But in general, for a huge portion of the S-curve, if a person is pregnant, they will have HCG in their system. And this is why HCG tests, HCG pregnancy tests, are an indicator of pregnancy, not proof of pregnancy. If we turn this into shorthand, we can say if A, then B. Okay, that's the form of this statement of fact. Okay. Now, what Miss Owens does is she takes this fact and she turns it around. She says, I have HCG in my system. Therefore, I am pregnant. What exactly did she say? Let's go back. She said, proof of pregnancy backed by science. This is what she's saying. So she's saying B is true. She has HCG in her system. And she's saying if A, then B. And then she concludes, conclusion, A is true, that she's pregnant. She says, I have HCG in my system, therefore I'm pregnant. Okay. The problem is, this is a logical fallacy. Okay. Let's go look for it. This is asserting the consequent, or affirming the consequent. We're going to look this up. Affirming the consequent is a logical fallacy where someone incorrectly concludes that if a condition, the antecedent, is true, then the consequent must also be true, even if the consequent can occur for other reasons. Okay, let's look at it. The fallacy. The error lies in assuming that because if P, then Q is true, and Q is true, then P must be true. This is exactly what she's done. Example. Here's a good example. If it's raining, let's make it a fun example. If it's raining at the bachelor mansion, then the driveway of the bachelor mansion is wet. Okay. Now, if we go there and we say, hey, the driveway at the bachelor mansion is wet, I guess it must be raining. Okay. This is a fallacy because the ground could be wet. The driveway at the bachelor mansion could be wet for other reasons, like somebody using a hose. The production assistants hosing down the bachelor mansion driveway because a wet driveway looks neater on film than a dry driveway. Okay. This is a fallacy. People can have HCG in their system for a variety of reasons. Pregnancy is only one. It's like a headache could be an indicator of a brain tumor, but it doesn't let you infer that you have a brain tumor because people can have headaches for a variety of reasons. So, this, affirming the consequent fallacy, is the fundamental fallacy underpinning her entire case and her entire position. And it is illogical, and it is not grounded in logic, reason, or science. Let's go back to the blog. Yet Judge Mata ruled I was not pregnant. I mean, here's the thing. It's kind of like when you go to court and you say, okay, did someone commit a crime? And the jury says, we're not convinced of the crime. They committed the crime, so they're not guilty. The jury is not saying that the person is completely innocent. They're just saying the state never proved their case. Okay? So it's not the case that Judge Mata conclusively determined you weren't pregnant. The problem was you claimed you were pregnant, Miss Owens, but failed to provide sufficient evidence. And in the face of a lack of evidence, you have to conclude that the person was not pregnant, because the default state, again, of people is not being pregnant. And if you can't prove that you were pregnant, even if you were, then no one should conclude you were, because you failed to meet the burden of proof. Okay. And the appellate court upheld that ruling without engaging with the statute, the evidence, or verified positive pregnancy tests. Well, the problem here is the appellate court was looking at issues of process. Okay? It's not the appellate court's job to say whether you were pregnant or not. The appellate court doesn't deal with the facts of the case. They deal with the legal issues of process in the case. Was the law applied correctly? Did anything inappropriate happen? Okay? So this whole paragraph doesn't make any sense. It appears she's looking for the appellate court to worry about whether she was pregnant or not, but that wasn't their job in this matter. So I don't understand what this whole paragraph is about. They didn't cite ARS 25804. They didn't even explain how someone who meets and exceeds the statute's requirements could be deemed to have filed in bad faith. Okay, it's not about the filing. It's about the fact that, the whole thing occurred. You can file, but once you file, you have a burden of proof to prove your claims. And because you didn't, and because it was proven that you did very sketchy things, like alter evidence, tell people things that weren't true, it's just the whole exercise was bad faith. Nobody is saying you shouldn't have filed a paternity case if you thought you were pregnant. The problem is you never went and got clinical proof of pregnancy. You never went and got clinical proof of paternity. You never went and got clinical proof of miscarriage. 3 different phases of this supposed pregnancy where you could have gotten and obtained clinical proof, and you failed to do so. And that failure and the resulting bad actions of altering evidence, not providing evidence, lying on the stand in other matters, is symbolic of bad faith. So your actions had these consequences. And you can try to rationalize them by saying, like, I was too scared to go to a doctor, this, that, the other thing. I wanted to have a feral pregnancy in the woods. You can Monday morning quarterback all you want, but you filed a court action and then failed to meet the burden of proof required by that court process. That's the fundamental problem here. And you can complain about it all you want, but you have to deal with the consequences of your actions. Okay. If a woman who submits medical proof, you didn't submit enough medical proof. You submitted an indicator, not proof. So this whole if-else argument in this sentence is going to be wrong because the first claim is wrong. You didn't have good enough medical proof. I'm sorry. You could have, but you didn't. If a woman who submits medical proof can be told she made it all up, if it looks like you're committing fraud, that is a potential judgment. If you don't want people to think you're committing fraud, you have to provide better evidence. What chance does anyone have? The other people have an amazingly great chance because they can provide good evidence of their claims in keeping with logic, reason, and science, which is not what you did. I'm sorry. What is the legal standard now? Certainty beyond miscarriage? Full-term delivery? Because that's not what the statute says. You claimed you were pregnant with twins and had no clinical proof. You claimed paternity by a specific person with no proof. You claimed you had a miscarriage with no clinical proof. You had a handful of HCG indicator tests that could have come from anything. That's not good enough. It's not good enough to get through a family court paternity case where you're asking for paternity, parenting time, child support, and all of these things. If you ask for those things, you need to be ready to back it up. Number 3, I tried to withdraw. They sanctioned me anyway. Arizona's Rule 26 of the Rules of Family Law Procedure isn't a suggestion, it's a safeguard. It was created to ensure that before any sanctions can be imposed for alleged bad faith or improper filings, the accused party is first given notice and a fair opportunity to withdraw or correct the issue within 10 days. So if you go back to before Mr. Echard even had legal counsel, in his very first response to this matter, he provided notice that he wanted sanctions. And then, plenty of time went by, way more than 10 days. Also, I believe if you go back to Mr. Echard's original response, he wasn't asking for fees and sanctions under Rule 26. He was asking for them under Rule 25 or Rule 11 or some other rule, if you go back and look at his handwritten notes. So this Rule 26 is really a red herring. This safe harbor provision is meant to protect litigants from being blindsided by crippling financial penalties without warning. No, it's not. Oh my gosh, look, if you file something, you can withdraw if you do it before there's a response from the respondent. But in this case, Mr. Echard responded. Once you respond, you are locked and loaded. You're going to need to see this thing through, okay, until the court dismisses it or there's a judgment or whatever, okay? You're in it. You cannot put the toothpaste back in the tube. But that's exactly what happened to me. Of course, because to get through a paternity case as the respondent, Mr. Echard needed a ruling of non-paternity, and he asked for his attorney's fees. So the court had to finish that. And if he incurred fees during that process, and the judge says you have to pay his fees, then you have to pay his fees. This is a repercussion of going to court. This is what can happen. You may have to be on the hook for paying his fees. There's no way to weasel out of it. And it's not right to be able to drag a public figure to court, make a bunch of claims, and then say, whoops, I guess it's over, even though my claims, yeah, I was pregnant. I was always pregnant with his kid, but now I'm not, so we're done. That is an offensive action taken against the respondent. It has negative consequences to him. So once he has responded to your case, The case needs to play out. He needs to be able to get the correct judgment in response to the claims you made. You cannot just make claims and then walk away. That's not how it works. After I miscarried, the paternity case was on the court calendar for administrative dismissal. Exactly. And the problem is, if it was dismissed administratively, then you could have gone off and said, see, the court never said I wasn't pregnant. The court never said he wasn't the father. And you can make whatever claims you want in the public domain without an official ruling or determination. I had no intention of continuing litigation. It doesn't matter. As soon as the respondent replies, the case will play out. And if you don't bring good enough evidence, then you failed. But then Echard, who had incurred no legal fees up until this point, hired a lawyer and moved to reinvigorate the case. Reinvigorate. This is obfuscation with this word, reinvigorate. No, they wanted to finish the case with a correct ruling, some sort from a judge, okay? And determine who's going to pay legal fees. First of all, I don't believe he had no legal fees up to that point, because in order to respond, in order to do various things, if you have to spend your time, if you have to drive to the court and file something, there's probably a filing fee. It could be $5. But $5 is not no legal fees. So I don't believe it was no legal fees. If you're arguing they were trivial legal fees, maybe that's true. But I disagree with the word no. It's not factually correct. It's not mathematically correct. Okay. The other problem is legal fees, in terms of a determination from a judge on who pays legal fees, happens for the entire case, beginning to end. The case was not over. So it is irrelevant. Okay, look, if you say the entire case goes from time t0, okay, to tn, and your argument is that there's some point in the middle, t0, and then a tx, and then there's tn when we're at the end. If your point is that his attorney's fees from T0 to TX are $0, but then from X to N is, some number, M dollars, it's irrelevant because the attorney fee determination is over the entire case. So all that matters is the summation of all of the fees. It doesn't matter that there were 0 fees between this point in time and that point of time. You have to integrate the fees over the entire duration, T0 to Tn. So this argument is just mathematically disingenuous. The moment he did, I filed a motion to dismiss with prejudice, the strongest legal step I could take to permanently conclude the matter. Yeah, we get it. You wanted to get out of the case without a determination of non-paternity and without any determination that might saddle you with the fees. I get it. You wanted to get off after making a bunch of claims without having to prove them. That's disingenuous behavior. You're admitting it. You're admitting this disingenuous behavior. I wanted to go to court, make a bunch of claims, and then get off without paying any bills or being held to task for my claims being insufficiently evidenced. I get it. That's what you want. That should have been the end of it. That's what you want. I know, you wanted to get away with making claims and face no consequences. That's not how the world works. There are consequences for our actions in the world. Instead, Echard's attorney, Greg Woodnick, filed a motion for sanctions under Rule 26 without ever serving me the required notice. I'd have to go back and look at the court document, but I think there was notice. In any case, no written warning. I think one of the responses once Miss Owens' attorney, Mr. Gingras, was on the case, explained how this was okay, his Rule 26 filings. The problem was, they just sort of withdrew it because the original request for fees and sanctions was under Rule 25 anyway. So the 26th thing was, it was kind of unnecessary. So in order to minimize the amount of back and forth motion litigation that would have stretched out the case and made the attorney's fees even worse, they just withdrew this whole thing about 26. Given that they withdrew it, it became irrelevant. This is the second time in this blog where she's harped on things that are effectively irrelevant. Okay. First was the harmless error, and now the Rule 26. I don't know why she's harping on things that are irrelevant. You need to understand what matters and what doesn't matter in this case. No 10-day correction period, no opportunity to withdraw, although I had already tried to. Yeah, we get it. You tried to get out of this without facing any consequences. It's not a good look. Months later, Wouldn't quietly withdrew the motion. What is it quietly? There's a motion. It's on the docket. It's in the public record. There's nothing quiet about it. What? This is a red flag linguistically, guys. You see these adverbs? Quietly. She's trying to pull something over on the reader here with this type of language. All motions go to the docket. They're all public record. There's nothing quiet about them. People on YouTube read through them, try to understand them. It doesn't make any sense quietly. It's a non sequitur. Only after my attorney, Mr. Gingras, pointed out that filing it without following Rule 26 mandatory procedures was itself a violation. That's a point of contention for sure. That was his argument. And, Attorney Woodnick had a response to that and said, look, we could battle this out because I think I'm right, you think you're right, but that would just waste time and money. Let's not waste time and money. And of course, she leaves all that out because she doesn't want to talk about that. I mean, that's another problem with, disingenuous writing when people omit things that matter. But by then, the damage was done, even with no active Rule 26 motion on file and with nothing left to litigate. That's not true. There's the matter of paternity or non-paternity that has to be ruled on, and there's the matter of attorney's fees and potential other sanctions that are up to a judge's discretion. Okay? So if the judge wants an evidentiary hearing in order to make a ruling on those things, that's what the judge can do. And that's what the judge did in February of 2024. He said, we're going to have an evidentiary hearing in June. If you didn't understand why the judge did that, your misunderstanding of the case, is not an excuse. Judge Mata still imposed nearly $150,000 in attorney's fees, citing bad faith conduct. Yeah. You could have gone to a consistent OBGYN and gotten fetal heartbeat monitoring, a consistent set of ultrasounds to prove that you were pregnant. You could have gotten paternity results from a real pregnancy to prove that Mr. Echard was the father. But all of those DNA tests came back little to no fetal DNA. So you failed to prove paternity. And if you think you miscarried, you could have gotten clinical proof of miscarriage. But you didn't have that either. So there's three things fundamentally in this case where you failed to provide sufficient evidence. And then on top of that, altered evidence, said things that weren't true, misrepresented facts under oath. This is bad faith conduct. The appellate court upheld that decision without reconciling the absence of a valid motion, proper notice, or the required filings under Rule 26C. Because again, Rule 26C was irrelevant, just like the harmless error was irrelevant. There was no ultrasound from a Planned Parenthood to Greg Woodnick, so anything about Planned Parenthood is irrelevant. The Rule 26 motion was withdrawn, so Rule 26 is irrelevant. Everything else is under other rules of process for court. You're harping on things that don't matter. Why? Because it's the only straw you can grasp to. You need to face reality. Read through the final ruling. Read through the appeals court's final ruling. Come to terms with reality. By affirming sanctions under these conditions, the appellate court has effectively gutted the protections Rule 26 was designed to provide. Rule 26 was withdrawn. Why are you talking about it? Where a litigant tries to do the right thing and is punished anyway. You did not try to do the right thing. The right thing would have been getting a consistent OBGYN, getting fetal heartbeat monitoring and ultrasounds for your high-risk twin pregnancy. The right thing would have been determining paternity. The right thing would have been documenting a miscarriage with clinical evidence. You didn't do any of those things. Those things would have been the right thing. Why would someone not do those things? Fraud is a reasonable answer. If left standing, this ruling will chill legitimate findings across Arizona. No, it won't. Your case did not create a new precedent. Your case did not create new law. The judges looked at the existing law that is already there and applied it. That's what they've always done since it was written, and that's what they will continue to do. Leaving people afraid to engage with the courts at all. The courts are not there for you to use them to bring a filing against someone in a retaliatory way for free. That's not what the courts are for. The courts are there to apply the law and make judgments. And if they decide you need to pay the bill, then you need to pay the bill. Because even following the rules may not be enough to protect them. Yeah, I mean, you can follow all the rules to the T, but if you bring a claim without sufficient evidence, you will fail. It doesn't matter whether your claims were true or not. You need to meet a standard of evidence that will convince the judge, a jury, the public. The fundamental problem here is that you failed to meet that standard of evidence, and you don't see it because you just want us to trust me, bro. That's not how science works. You don't just get to say, trust me, bro, and everybody will believe you. It's disappointing. Number 4, they misrepresented my motion to dismiss with prejudice. To summarize, we're summarizing now. The case was already scheduled to be administratively dismissed by the court. Sure. And after learning I had miscarried, I chose not to pursue it any further. Tough luck. The respondent chose to pursue it further and see it to the conclusion because you filed it, as is his right once he responds. Your misunderstanding of that is not an excuse. I didn't file anything else. It's irrelevant. I was letting it close quietly. That's also irrelevant. So what? But then Echard unexpectedly moved to revive the case. Revive? I mean, he filed motions within the appropriate time frame. That's continuing the case, not reviving it. Note the language here. This language, it's a microaggression against the respondent. It's not accurate. Attempting to force the litigation to continue. Again, linguistically, she's turning it around as if he's the petitioner somehow. He is not the petitioner, he is the respondent. Have we forgotten? Only at that point did I file a motion to dismiss with prejudice, a formal request to permanently end the case, ensuring it could never be reopened. And I guess your motion failed. Shocking. But the appellate court twisted my intent. They wrote, that administrative dismissal would have been without prejudice, so it would not have precluded Owens from initiating a future paternity action. I don't know if this motion was filed to dismiss with or without prejudice, or perhaps it doesn't matter and it just goes without prejudice anyway. I'm actually not sure about this. I think the fundamental problem here is if a motion to dismiss with or without prejudice was going to fail, this all sort of becomes irrelevant. So I don't know why it matters. Let me ask the obvious. Why would I refile a paternity action after I told the court I was no longer pregnant? I don't know. This is just more speculation, right? Like, I don't know. No one said you would. They merely said it wouldn't have precluded you. They didn't say you would. That's what, without prejudice, it doesn't preclude doing the same case again. Why would I take the extraordinary step of filing a motion to dismiss with prejudice if I had any intention of refiling? Yeah, I agree. But it's irrelevant. Your motion to dismiss was denied, whether it was with or without prejudice. I don't know why we're nitpicking on this. It doesn't seem of any substance here. The court's interpretation defies logic. I mean, if they say an administrative dismissal, oh, I see what they're saying. They're saying the administrative dismissal, not Miss Owens' dismissal. The administrative dismissal, if Miss Owens hadn't filed a motion, would have been without prejudice, so it would not have precluded Owens from initiating future paternity action. That's true. So they're just making a statement of fact. I guess since that didn't happen, it doesn't matter. But they're just stating sort of a logical fact. And you can't say it defies logic if their statement of fact is true. If my friend comes to my house, I'll offer him a bottle of water. My friend may never come to visit. So it's irrelevant, even though, the fact that if something were to happen, I would do something is true. I think she just doesn't understand logic. If there had been an administrative dismissal, then it would have been without prejudice. They're just stating an if-then clause. They're not saying A is true. They're saying if A were true, therefore then B. You know, these things can be correct. Let's go back here. If you say, if A, then B, and we think this is true, if Nick comes to Bruce's house, then Bruce will give him a water. Did Nick ever go to Bruce's house? No. So we know that A is false. If A, then B is still logically true and logically sound. It doesn't mean those things happened. It's just a form of information, a form of argument. This is what she doesn't understand about logic and reason. Let's go back to the document. I sought to end the case legally and respectfully, and the appellate court made it sound like I was keeping the door open. They're just making a statement of fact about administrative dismissals. They never said you didn't file a motion to dismiss with prejudice. That would defy logic. If you had done something and they said you didn't do it. But that's not what's happening here. This is a very strange argument in this section. Makes no sense. Okay, number 5. They penalized me for appealing these very violations. Yeah, that can happen. If you file an appeal and there's attorney's fees, you may be on the hook for those fees. Oh my gosh, there's no free lunch here, guys. At the end of the opinion, the appellate court wrote, quote, Owens' position on appeal is unreasonable. They didn't buy your appeal. I'm sorry. I don't think people were surprised. Her Rule 26 argument is not grounded in law or fact. You failed. You failed. Likewise, her assertion that the trial judge was biased and committed structural error does not meaningfully address the trial court's rulings below and ignores the applicable jurisprudence. You failed. You failed to meet the burden of proof with your evidence or your explanations in the original case and in this appeal. I don't know what to tell you. Then they awarded Echard his appellate fees. We therefore award Echard his reasonable attorney's fees and costs on appeal. Yeah. If you didn't want to get stuck with the bill as a potential outcome, a consequence of your actions, you shouldn't have filed an appeal. Appeals, statistically, don't win. If you thought you had a greater than 50% chance of winning this appeal, statistically, you were misinformed. In family law, appellate fee awards are uncommon and typically reserved for appeals that are clearly frivolous or malicious. Interesting. Okay, so they thought your appeal was frivolous or malicious. I tend to agree. Mine was neither. Prove it. I raised serious constitutional and procedural issues. No, you didn't. The trial court relied on evidence outside the record. No, it did not. It did not rely on that evidence. There was never an ultrasound sent from Planned Parenthood to Greg Woodnick. So how could it rely on any information about Planned Parenthood? It couldn't. There's no foundation. Misapplied Rule 26. Rule 26 motions were withdrawn. It's irrelevant. You have a critical failing of understanding what is relevant and what is not relevant in this case. And that's why you're writing this blog. And ignored Arizona's paternity statute. No, they didn't. Under ARS 25324A, a fee award requires courts to consider both the financial resources of the parties and the reasonableness of their positions. Of course, the court determined you're unreasonable. The appellate court admitted the record does not support a disparity in resources, yet still found my appeal unreasonable and awarded fees. Yes, they did. That outcome contradicts both the text and spirit of the statute. No, it doesn't. They found your appeal unreasonable and awarded fees. Between the lower court and appellate rulings, I'm facing a combined judgment that is likely going to be at or surpass $200,000. Yes. There are consequences to actions. I understand you may have not faced consequences like this in your life before, but that does not mean that these consequences are unreasonable. All for filing a paternity petition I had every legal right to file. You are not facing the judgment merely because you filed a paternity petition. You have every legal right to file. It's what happens after you file that is important. You have to prove your claims in court. If you don't, you will be stuck with the bill. This is adult human responsibility. You need to live up to your responsibilities and pay this bill. Trying to continue on with other appeals, other actions, is clinging to straws that have no basis. They're not going to work. Quit while you're ahead. I know you won't. I mean, you're behind, but you could be more behind. Quit before it gets any worse. I don't think you will, but that's my advice. Where we go from here? We are preparing to file a motion for reconsideration with the Arizona Court of Appeals. I don't know why. If you read the judgment from the Court of Appeals, maybe I'll do that on another stream. They brought the hammer down on your appeal. It was a bloodbath for you. What do you want them to reconsider? If that is denied, we will seek review from the Arizona Supreme Court. And if necessary, the United States Supreme Court. These are three things you can try. But in doing these things, to me, it seems like you're just trying to stay in the mode of litigation, stay involved with the respondent's life, stay involved in having an action occur, as opposed to accepting the responsibility that you owe this money, paying the bill, and moving on with life. To me, it's if you read the original judge's ruling, if you read the appeals court ruling, it's very clear that the likelihood of any of these three things moving forward working is close to zero. I can't believe that at this point you think you can win something here. So to me, any action from here on out moving forward is not a legitimate attempt to win this case. It's a way to keep court action going because you seem to be addicted to this. It's not healthy. It's not right. It's not good. This appeal raises profound constitutional and procedural questions. No, it doesn't. Oh my gosh. Can a judge decide a case using information that was never testified to as evidence? No, they can't. And in this case, they did not. They did not decide the case using the information that some LA Planned Parenthood was closed on Sunday. That was not the determining detail in deciding this case. It's irrelevant. This point is irrelevant. Can Rule 26's protections be bypassed? Rule 26 motions were dismissed. They weren't bypassed. You don't have an understanding of how these motions work. Letting courts impose six-figure sanctions without serving a safe harbor notice. Yeah, they can stick you with the bill once the respondent has responded. Welcome to life. Without a live motion pending, without a properly noticed hearing, and without applying the correct legal standard, they applied the correct, you didn't prove that they applied the wrong legal standard in any way. This is a claim with no evidence. The court does not agree with you. Do litigants have a right to procedural fairness before being sanctioned? This case was handled with procedural fairness. You cannot just take the fact that you lost as proof that something unfair happened. Can a woman who submits lab-confirmed urine and blood-positive pregnancy tests, along with photographic and video evidence of a visibly pregnant abdomen? Photos and videos of your stomach is not clinical proof of pregnancy, or let alone paternity. And again, we've gone through the whole thing about how HCG is an indicator, not proof. And you're just so stuck on it. This logical fallacy. It's anti-science. It's anti-biology. It's anti-chemistry. It's an affront to every single person who has had clinical proof of pregnancy, who has had clinical proof of paternity, who has had clinical proof of miscarriage. It's an affront. It's disrespectful to conflate bad evidence with good evidence. It's not how science works. Can this person still be told by a judge that she was never pregnant? If you can't prove that you were pregnant, then a judge is going to say, I don't think you were pregnant. That's rational. And then be sanctioned for filing a paternity case she was legally entitled to bring under state law. Yes, you can be sanctioned. Yes. Your evidence wasn't good enough. Pay the fees. That's the whole point of this that you don't understand. Your evidence was not good enough. You didn't go about any of this the right way. Now you have to pay the bill. If Arizona law allows a woman to file a paternity petition while she is still pregnant, is she subject to punishment if she later miscarries? You aren't being punished with attorney's fees for miscarrying. You have no clinical proof of miscarriage. This whole sentence is a non sequitur. Can an appellate court rubber stamp all of this? And this is linguistically dismissive of the appellate court because she doesn't like their answer. Rubber stamp. The appellate court takes your appeal, they review it, and they rule on it. If you don't like the ruling that upholds the original ruling, it's not that they rubber stamped it without ever looking at it. This is disingenuous language. And then impose even more financial penalties simply because the woman dares to appeal. Dare to appeal? If you appeal, you're engaging in more litigation. Litigation has a cost. You seem to think that litigation should not have a cost. It does. There's no free lunch. Can they impose lawyers' fees on someone during an appeal because the appeal didn't win? Sure. That's what they did. It seems like you don't like the laws the way they're currently written because they don't let you get away with doing whatever you want for free. That is a selfish, egotistical, terrible worldview. The world does not exist to let you do whatever you want for free with no penalty. That's not how the world works. If you think you should be able to do whatever you want and face no repercussions, if you do not live up to the standards of the activities you engage in, going to court without sufficient evidence, then I don't know what to tell you. It sounds like a psychological problem. Your worldview of how the world works is fundamentally broken. I'm incredibly fortunate not to be fighting this alone. My attorney isn't doing this for money. Well, attorneys don't do things for no reason, so he must have a reason. What is it? He took on my appeal without charging me a dime, and he's committed to taking this case as far as it needs to go, even to the U.S. Supreme Court. Why? Because he believes in something bigger than all of us. That the Constitution means something. What constitutional right has been violated for you in this case? Due process? The due process is not optional. I'm sorry, but having a ruling in court go not your way is not a due process violation. And that's all that's happened here. Now, if you can convince me that something nefarious happened, that these judges did not apply the law correctly, I'm willing to listen and be convinced. But so far, you failed to convince me and the vast majority of the general public, as well as 5 different judges. You failed. And you're not going to convince us by simply saying you're right in a blog. It doesn't work that way. And that when the system fails this profoundly, someone has to stand up and say so. I mean, good luck. The problem is, when you stand up and say so, you have to have convincing arguments. And we've spent about an hour and a half going through this blog, and I've explained why your arguments are not convincing. So I guess it's back in your corner. If you want to keep appealing this, you can. But I don't see any basis for it. Which leads me to believe you're not appealing and appealing and appealing again and doing these 3 new things because you think there's some sort of grand conspiracy and the law has to change. I think psychologically you want to be engaged in lawfare, and these appeals afford you the ability to do that. That's my personal opinion. I think it's a psychological problem. And that's where we are. This isn't just about what happened to me. It's about making sure it never happens to anybody else. Well, presumably, anybody else that files a paternity case in family court in Arizona will come to court with clinical proof of pregnancy, will come to court with babies, will come to court with proof of paternity, will come to court with clinical proof of miscarriage, should a miscarriage occur. This is happening to you because you failed to bring sufficient evidence. Don't lie to yourself and tell yourself that there's this grand conspiracy that 5 different judges and the entirety of the court of public opinion have it wrong. That's delusion. It's delusion. You failed to meet the burden of evidence because you don't understand science, you don't understand logic, you don't understand the standards of evidence that are needed to convince people of your claims. I don't know why that is. I could speculate, but I will refrain. That's where we are, guys. That's this blog. We'll see where we go from here. Like she said, they have about 3 potential things they could do. They could file this motion. They could go to the Arizona Supreme Court. They could go to the United States Supreme Court. We'll see if they do any of those things or file any other litigation. Until then, I remain unconvinced. This is Bruce from Oregon. Bruce the Moose. This is the Bruce from Oregon Show. If you've stuck around this long, thanks for your time. Have a good one.